Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
We have an exciting show for you. A warning for green card holders. Crimes and violations can cost you your status. So whether you are in the Caribbean or you have family in the U.S. that are green card holders, please listen, pay attention, and be warned. And green card holders, you should file immediately for citizenship. Ask the Lawyer starts now.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with this week's immigration news based on an article by Brian Figueroa, Esquire. Why green card holders should immediately file for U.S. citizenship in light of the DHS interim final rule. The U.S. Department of Homeland Security's DHS upcoming interim final rule, IFFR, on alien registration and evidence of registration, set to take effect in April 2025, introduces new obligations and potential penalties for non-citizens residing in the United States. Given the increased scrutiny, stringent registration requirements, and potential legal consequences for non-compliance, lawful permanent residents, LPRs, or green card holders should prioritize filing for U.S. citizenship immediately. This article analyzes the new rule and explains why naturalization is the safest and most beneficial path forward for green card holders. 1. Increased registration and compliance burdens. Under the IFR, all non-citizens, including green card holders, will be required to register their presence and provide fingerprints if they remain in the U.S. for 30 days or more. This introduces a new layer of bureaucracy that U.S. citizens are exempt from. Frequent documentation checks. LPRs over the age of 18 must always carry proof of registration. Failure to do so could result in misdemeanor charges, fines up to $5,000, or imprisonment for up to 30 days. Change of address requirements. LPRs must notify DHS of each change of address within 10 days. Failure to comply could lead to legal consequences. 2. Harsh penalties for noncompliance. The IFR imposes strict penalties on those who fail to comply with new registration and fingerprinting requirements. Failure to register or provide fingerprints, up to $5,000 in fines, imprisonment for up to 180 days, or both. Carrying proof of compliance is mandatory. If an LPR is stopped and cannot provide documentation, they face misdemeanor charges. Failure to report a change of address. A misdemeanor offense, punishable by a fine of $5,000 and up to 30 days in jail. For green card holders, this means increased exposure to legal risks, a concern that U.S. citizens do not have to deal with. 3. Risk of deportability for minor violations. One of the most concerning aspects of the IFR is that fraudulent registration or failure to register could lead to deportation proceedings. This means that even minor mistakes, such as missing a deadline or misunderstanding a requirement, could have life-altering consequences. Mistakes in paperwork or delays could be considered violations, placing green card holders at risk. Citizenship offers permanent protection from deportation, whereas LPR status always carries some risk of removal. 4. The threat of future policy changes. The IFR is a reminder that immigration policies are subject to change, and not always in favor of non-citizens. Future administrations or legislative actions could increase filing fees and processing times for green cards and naturalization. Introduce additional restrictions for LPRs, making it harder to travel or renew documentation. Tighten pathways to citizenship, making it more difficult for green card holders to naturalize in the future. Filing for U.S. citizenship now ensures that green card holders secure full legal rights before any further restrictions are enacted. 5. Citizenship provides freedom and security. By becoming U.S. citizens, green card holders eliminate the need to comply with these new registration requirements and the risks associated with them. U.S. citizens do not have to register their presence, provide fingerprints, or carry proof of registration, are protected from deportation and cannot be removed from the country under normal circumstances, have unrestricted travel rights and can live abroad without worrying about re-entry restrictions. Furthermore, citizenship grants access to federal benefits, voting rights, and greater employment opportunities, advantages that LPRs do not enjoy. The time to naturalize is now, with the DHS interim final rule introducing stricter registration requirements, significant penalties for noncompliance, and an increased risk of deportation. Green card holders should immediately pursue U.S. citizenship. Becoming a citizen eliminates bureaucratic burdens, legal vulnerabilities, and future uncertainties, ensuring long-term stability and protection in the United States. For green card holders who qualify, delaying the naturalization process is no longer an option. It is an unnecessary risk.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
Hello, people out there. I'm Julian from St. Lucia, and I'm here in Mr. Figaro's office. Mr. Figaro represented me for past, 10 years. I was going through some removal proceeding, and I go to several lawyers. Some of them asked me to run away. Some of them said they cannot do anything for me. And my Consulate General, Jeremiah Hyacinth, he recommended me to Mr. Figaro. And right now, I go through a lot with Mr. Figaro. Mr. Figaro is the only one that stands with me. And right now, I believe I'm the happiest man in this world right now with a 10-year green card. 10 year, and in the next 2.5 years, I'll be filing for my citizenship. And that's me, happiest man today. Thank you.
Facing deportation due to overstaying your visa or immigration violations, you need the right legal team on your side. The law firm of Figaro and Associates, located in Brooklyn, New York, specializes in deportation defense. Our experienced immigration attorneys can help you fight removal, apply for waivers, or seek asylum if needed. Don't face this alone. Let us help you protect your future. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845. Figaro and Associates. The help you need when it matters most.
Estate planning is a necessity, not a luxury. Let the law firm of Figaro and Associates help you protect your legacy, assets, and loved ones. Get estate planning consultation on wills, living trust and probate, power of attorney, health proxy, deed transfers, providing for special needs, disabled children and grandchildren, minimizing federal and state taxes. Call us right now at 855-768-8845. That's 855-768-8845. Or schedule an appointment at www.askthelawyer.us. That's www.askthelawyer.us.
Does the thought of bankruptcy keep you up at night? The fear of losing your home, the harassing calls from creditors, your wages being garnished. How will you survive? What will you do? The law firm of Figaro and Associates will protect you. Figaro and Associates is one of the most sophisticated consumer bankruptcy law firms in the country, and they will fight to protect your rights. Have the peace of mind knowing that your case is being handled by experienced consumer bankruptcy attorneys. Don't let the bank take your home. There is a way out. Call the law firm of Figaro and Associates today for a consultation. 855-768-8845. That's 855-768-8845. The law firm of Figaro and Associates will explain all your options and help you decide the best course of action. Schedule your consultation today. 855-768-8845 or visit 311bankruptcy.com. That's 855-768-8845 or visit 311bankruptcy.com and put those sleepless nights to bed.
Hi, my name is Brian Anthony Figaro, and you are listening to Ask the Lawyer with my father, Brian Figaro.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figaro and Associates, and your presenter with this week's immigration news. Green card holders warned. Criminal convictions and immigration violations may lead to revocation of status. Federal authorities have issued a stark warning to lawful permanent residents. Those who violate U.S. laws, including criminal statutes and immigration regulations, may face the revocation of their green cards and subsequent removal from the United States. In a statement posted on X, formerly Twitter, U.S. Customs and Border Protection, CBP, emphasized the federal government's authority. Under our nation's laws, our government has the authority to revoke your green card if our laws are broken and abused. However, immigration advocates and legal experts caution that revocation of lawful permanent resident status is not automatic. The Department of Homeland Security, DHS, must follow due process, which includes issuing a notice of intent to rescind and affording the individual the right to a hearing before an immigration judge. Only after adjudication may status be formally rescinded. Under the Trump administration, agencies such as CBP, U.S. Citizenship and Immigration Services, USCIS, and Immigration and Customs Enforcement, ICE, have dramatically expanded their online presence, utilizing social media to issue high-visibility warnings. These efforts have included campaigns urging undocumented immigrants to self-deport and spotlighting individuals arrested on criminal charges. In a parallel crackdown, the administration is also targeting certain foreign students and permanent residents allegedly linked to pro-Hamas or anti-Israel activism. According to statements by Secretary of State Marco Rubio, the government is actively revoking visas and green cards of individuals it identifies as Hamas supporters. On March 9th, Rubio posted on X, "We will be revoking the visas and slashed or green cards of Hamas supporters in America so they can be deported." USCIS reinforced this message on May 5th, stating via X, "Green cards and visas will be revoked if an alien breaks the law, supports terrorism, overstays their permitted visit time, performs illegal work, or otherwise violates the terms on which we granted them this privilege or compromises the safety of our fellow Americans. Why this matters? This warning is part of a broader enforcement strategy that underscores the Trump administration's hardline immigration agenda. President Trump has reiterated his pledge to deport millions of undocumented immigrants and has characterized all individuals in the U.S. without legal status as criminals. The scope of enforcement extends beyond undocumented immigrants. Lawful permanent residents and individuals with valid visas have increasingly been subject to detention and removal proceedings based on alleged violations of immigration or criminal law. Key facts. As of January 1, 2024, there were approximately 12.8 million lawful permanent residents living in the United States, according to estimates from the Office of Homeland Security Statistics. While possession of a green card grants permanent resident status, it does not immunize individuals from removal proceedings if they are found to have violated the conditions of their status or committed deportable offenses. USCIS has stated that legal status may be revoked for such violations, subject to proper legal procedures and adjudication.
Attention green card holders. Have you been outside the United States for more than a year? Are you holding an old green card without an expiration date? These situations can jeopardize your permanent resident status. At Figueroa & Associates, we specialize in immigration law and can guide you through these complex issues. We are located at 26 Court Street, Suite 701, downtown Brooklyn. We are here to help you navigate the legal maze. Don't wait until it's too late. Call us today at 855-768-8845 to schedule a consultation. Protect your status and secure your future with Figueroa & Associates. Figueroa & Associates, your trusted partner in immigration law. Call 855-768-8845 now or visit askthelawyer.us.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa & Associates, your trusted partner and family.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay. But the law firm of Figueroa & Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845. Get the right legal.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Vacation romance, love or immigration opportunity. Experiencing a vacation in the Caribbean often proves to be an enchanting journey filled with lush landscapes, vibrant cultures, and warm-hearted locals. It isn't uncommon for tourists to find romance blossoming in such an inviting atmosphere. Yet, what begins as an idyllic love story can quickly become complex, especially when marriage and immigration issues intersect. This analysis explores the critical issues of discerning genuine marital intentions versus marriage for immigration purposes, commonly termed green card marriages, steps to establish proof of authentic love, navigating potential divorce, and finally, the process of bringing a spouse to the United States, vacation romance, love or immigration opportunity. The Caribbean, known globally for its captivating beauty, has become a frequent romantic destination. Falling in love during vacation seems simple, natural, and genuine. However, skepticism often arises when marriage quickly follows such brief, intense interactions, prompting legitimate questions about the genuine intentions behind the union. Under U.S. immigration law, marriage fraud is defined as marrying primarily to evade U.S. immigration laws and obtain immigration benefits. Understanding green card marriages. A marriage entered into solely for immigration purposes is considered fraudulent under U.S. immigration law. The United States Citizenship and Immigration Services, USCIS, actively investigates marriages, especially when they occur swiftly after meeting or have other red flags, such as large age differences, communication barriers, or significant cultural disparities. If USCIS suspects marriage fraud, the consequences can be severe, including the denial of immigration petitions, deportation of the immigrant spouse, and potential legal consequences for the U.S. citizen or permanent resident. Establishing proof of love. Given USCIS's heightened scrutiny, it becomes essential to provide robust documentation proving the genuine nature of the marital relationship. Examples of acceptable evidence include joint financial documents, bank accounts, credit cards, leases, or property ownership records indicating joint financial responsibilities. Photographic evidence, photographs of vacations, family events, or other significant milestones. Communication records, emails, texts, phone records, and social media interactions. Affidavits from friends and family. Statements supporting the legitimacy of the relationship from individuals familiar with the couple. Shared responsibilities, insurance policies, joint health care, and utilities. Documentation should span the duration of the relationship, illustrating consistency, shared life decisions, and mutual commitment. Addressing concerns of fraud. If doubts arise about the marriage's authenticity, it's advisable first to address these directly with the spouse. Open, transparent communication is essential to discerning true intentions. Couples counseling, conducted by a neutral third-party professional, can help clarify underlying issues or misunderstandings. Should concerns persist, seeking legal counsel specializing in immigration matters becomes imperative. An immigration attorney can advise on how to proceed cautiously, ensuring protection against potential fraud allegations. Considering divorce. In situations where fraudulent intentions become undeniable, divorce may become the most appropriate and necessary step. Divorce proceedings can occur either in the Caribbean or the U.S., depending on where the marriage was legally performed. Under New York state law, a divorce can be granted on multiple grounds, including irretrievable breakdown, abandonment, or cruel and inhuman treatment. It's important to document clearly and thoroughly the reasons for divorce, especially if immigration fraud is suspected. Legal advice is crucial here, particularly regarding potential consequences for both parties involved, including how the divorce may impact immigration statuses and future immigration petitions. Bringing a Caribbean spouse to the U.S. If the marriage is indeed genuine and free from suspicion of fraud, the next logical step is initiating the immigration process for the spouse. Typically, this involves 1. Form I-130, Petition for Alien Relative, filed by the U.S. citizen or permanent resident spouse, proving the existence of a bona fide marriage. 2. Consular processing, conducted at the U.S. Embassy, involving interviews to verify relationship authenticity. 3. Conditional green card. Upon successful entry, the immigrant spouse receives a conditional green card valid for 2 years. After 2 years, USCIS requires submission of Form I-751, Petition to Remove Conditions, demonstrating continuous bona fide marital relationship to remove conditions and secure permanent residency. Avoiding pitfalls in immigration. USCIS interviews during the immigration process can be stringent and invasive. Couples should be thoroughly prepared to answer detailed personal questions about their relationship history, living arrangements, daily routines, and future plans. Preparation tips include reviewing relationship history together, ensuring documentation of joint activities and responsibilities, attending the interview jointly and openly addressing questions. Conclusion: a romantic encounter during a vacation in the Caribbean that leads to marriage poses both exciting opportunities and potential challenges. Distinguishing genuine love from immigration opportunism involves thorough self-reflection, open communication, and diligent documentation. Whether confronting suspicions of marriage fraud, considering divorce, or initiating immigration proceedings, professional legal guidance remains critical in navigating complex international marital and immigration law. Ultimately, ensuring transparency and clear intentions from the outset helps mitigate risks, paving the way for a smoother transition into a genuine marital union and successful immigration experience.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figaro and Associates, your trusted partner in family immigration law.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figaro and Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figaro and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figaro and Associates today.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay. But the law firm of Figaro and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at www.askthelawyer.us or call us at 855-768-8845.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figaro of the law firm Figaro and Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.